Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order this morning. Madam Secretary, would you please call the roll?
My machine is not working. Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
I am present. Everyone is here. We do have a quorum. Thank you all for being pretty close to on time for a Friday. I appreciate that. Welcome to the members of the committee. Welcome to those joining us on the Zoom and to those who might be watching on the internet at the legislature's website or on our YouTube channel. Welcome to day 33 of the 81st session of the Nevada Legislature. We are finishing up week 5 today. Before we get started on our agenda, just a few housekeeping rules. People on the Zoom, members and guests, could you please make sure you mute when you're not speaking? That'll help with the audio feedback. And then for our presenters today, if you could please remember to state your name each time you speak, particularly after you are asked a question. That'll help with the minutes. I'll try to remind you to do that because it's not really a natural thing to do. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly fine, but we need to make sure we're being respectful of one another and this legislative institution. Finally, many members are using multiple devices to participate in this meeting: laptops, desktops, extra monitors, iPads, phones. We're just trying to manage this virtual environment, so please don't see it as a sign of disrespect or inattention if members seem to be looking away during today's meeting. With those housekeeping matters behind us, we're going to move to our agenda. Members, as you can see, we have 2 bills on the agenda today. We are going to take those 2 bills in order. So at this time, I'm going to open up the hearing on Assembly Bill 33. Assembly Bill 33 authorizes the establishment of paternity in proceedings concerning the protection of children. I'll let members know and members of the public know that there is a pretty substantial amendment that you'll find to the bill up on Nellis under the Exhibits tab, and I believe our sponsors will go through that. So joining us this morning on the Zoom to present the bill include Ms. Dagny Stapleton, Ms. Amber Howell, Ms. Megan Lucy, and the Honorable Justice Nancy Seda, retired. I think I am obligated to say that. So I want to welcome the 4 of you to the Zoom this morning. What we'll do is give you a chance to present the bill, and then I'm sure we'll have some questions, and after that we'll take testimony. So welcome to the Assembly Judiciary Committee on a Friday morning, and whoever would like to start first, please go ahead. It looks like maybe Ms. Stapleton is unmuted. So did you want to start off?
Yes, good morning. Thank you so much, Chair Yeager, members of the committee. Good morning, and thank you very much for the opportunity to present AB 33 to you today. My name is Dagny Stapleton. I'm the Executive Director of the Nevada Association of Counties. And as the chair mentioned, I have 3 presenters here with me today as well, who I would like to introduce. First, Amber Howell will provide the detailed presentation on AB 33 today. Amber is the director of Washoe County's Human Services Agency. That agency oversees the child welfare system in Washoe County. And because of her role, Director Howell is very familiar with child welfare and dependency cases and the process for determining paternity, which our bill today addresses. Also to help us present today and answer any technical or legal questions representing Washoe County is Megan Lucy. And finally, we are honored to have retired Supreme Court Justice Nancy Seda here also as a part of our presentation, and she will share her perspective on this issue with the committee also. Before I turn the presentation over to Director Howell, I would like to note, as the chair did as well, that we have submitted an amendment to the committee. We are proposing, as you can see from the amendment, to get most of the bill as we found a better way to accomplish what we wanted. There's actually a more simple change to the law, and we'll go through that with you. We did submit that amendment, and so we would direct you to look at the amendment as Director Howell goes over the bill. And with that, I'll turn it over to Director Howell.
Good morning, Chair and members of the committee. Thank you so much for having me today. My name is Amber Howell, Director of the Washoe County Human Services Agency, AMBERHOWELL. I want to go through a little bit of testimony, and then I'll go through the amendment and be happy to answer any questions. I'll start by saying that the greatest gift that we can give a child is closure through a forever family after they've been abused, neglected, or experiencing things that we wish they had not. No child or parent should have to mourn the loss of each other, but when it does, for a variety of reasons, we need not prolong the next steps. The quicker we can remove the anxiety from a child that's worrying about where they will be placed for the last time and have adoptive parents who promise to give them a childhood they deserve, free from instability and ambivalence, the sooner the child can close that chapter and begin anew. Children in the foster care system endure unanticipated trauma from the unknown of not knowing where they're going next. Not having a secure placement or the confidence that the adults in their life will be there for them impacts all facets of a child's well-being. Children should not grow up in our system. And the second we realize that reunification with their parents is not going to occur, we need to have a seamless process to find the next best option. We have several federal timelines, case management, court procedures, establishment of paternity, and all of those things take many steps and actions, and we want it to be seamless. And that allows the children to be navigated to the adoption track efficiently and, most importantly, exit our system. I want us to think for a moment about a child's clock. For most of us, we think of a lifetime of 70 or 80 years, a relatively long period of time to live, experience, and enjoy all the things that the world has to offer. But an individual has a very short time frame to be a child. Only about 20% of our lives is spent in childhood. And when you think about a child entering into the child welfare system, working on reunification, establishing paternity, and getting adopted could take up to 5 years. And by that time, a fourth of their childhood is already gone. They can't ever get these years back. So what this legislation addresses is the legal process that takes place when the kids are in the foster care system and need to move into the adoption track. In dependency hearings, in order to ensure that the biological parents of the child is resolved, the process for determining paternity has to occur. So what this bill does is it ensures that this process is uniform and efficient across the state by making sure the existing process in law, or rather in Chapter 126, is also used in child welfare cases. One thing I want to note is in 1995, Kaiser and the Center for Disease Control and Prevention conducted an adverse childhood experiences study called the ACEs study. And in short, what the study has found, and we have used this in the child welfare agencies for many years, is that adverse experiences for children between birth and 17, such as instability in their home and family involvement, can and is likely to lead to chronic health, substance abuse, and mental health issues later in life. So what this means is the more frequent and longer these experiences occur for a child, the more significant issues become later in life. That's why it is critical to have a very smooth and efficient process for children. With this legislation, as Ms. Stapleton mentioned, there's a beefy amendment, but I think she said it eloquently that we found an elegant way to simplify what we were trying to do. I will let you know that we have been busy working with all partners in our community, from the courts, child welfare agencies, public defenders, child support, legal services, the DAs, and we've all come to a place of neutrality or agreement based on the long amendment that I'm going to go through today. So I'll start with the amendment. So first, and most importantly, we are proposing to delete sections 1 through 11. In section 12, 1B and 2A, we are adding 432B. In section 13, we are adding 432B proceeding to 126. That's the adoption chapter. Section 14, adding confidentiality language and final order language, and then all remaining language is being proposed for deletion. So I will just close with, we don't believe, these are very difficult cases for us in the Child Welfare Agency. We don't believe that a parent wakes up one day and decides to be absent or to not provide for their children. But when this occurs for whatever reason, we need to be there for the child to provide an alternative plan that is safe, loving, and secure. Everybody longs for a parent to guide them, teach them, and love them unconditionally when biological parents cannot meet these tasks. And we need to have processes that streamline the myriad of events that occur for a child in the foster care system. This legislation has been proposed to provide clarification to ensure children have as much time on their clock as possible and give them as many happy years as we can. I thank you for your time, and I will turn it over to Justice Nancy Seda.
Good morning, members of the committee. Thank you for taking time to hear this bill. For the record, Nancy Seda, NANCY SAITTA. I join in the support of this bill and urge the committee to consider its most immediate passage. The process of adoption is one, as Ms. Howell described, that is long and tedious, and unfortunately, we don't often consider the needs of the child. I will tell you, I think many of you know this, I was a product of the system, and I was adopted very, very early. And so I had the great good fortune of being adopted and remaining in a family that put up with me through years where I wouldn't have put up with me. But the fact of the matter is that parenting, forever families, and permanency is the most important thing that any child can and should have. While the state can certainly do their best to create an environment to keep our children safe and protected, no child should be raised by the state. This bill allows for the process that is often far too difficult, far too tedious, to be streamlined, where all rights are considered, and in fact, the ultimate goal is to protect the welfare of the child. And in this bill, we take out some of those things in law that we often think are important, and indeed they are. Let me make that clear. The establishment of paternity is something that should not ever be taken lightly. But on the other hand, when it is clear that indeed the parent is absent and will continue to be absent or has no interest in the life of this child, our state should be able to step up and allow the child to move into that forever family with as much simplicity and ease as is possible. Again, I want to close with thanking you for considering this bill. I want you to know how very important it is to the state, to our welfare partners, to the judiciary, and to someone like me who, almost 100 years ago, had the great good pleasure of being adopted into a family that I think every child should have. Thank you.
Thank you so much, Justice Seda. Miss Lucy, did you want to provide comments before we had questions?
Thank you, Chair. Megan Lucy, MEGAN LUCEY, on behalf of Washoe County Human Services Agency. Through the chair, I'm here to answer questions that this assembly would have for me today. So I have no additional testimony other than to be here to answer any technical or legal questions proposed. Thank you.
Great. Thank you so much to the three of you for presenting and the four of you for being here for questions. Before I open it up for other questions, I just wondered, I think this is the first time in this session we've dealt with Chapter 432B. So I was hoping someone could just kind of give an on-the-ground perspective of, sort of what the issue is now and how the addition of 432B being inserted into some of these chapters, how that's going to streamline the process. If you could perhaps just walk the committee through what these proceedings are and how this will help, I think it'll be good for some background. And I don't know who particularly would like to do that. I'll just wait for somebody to unmute and answer that question. Thank you.
Yes, Megan Lucy, thank you, Chairman. Megan Lucy on behalf of Washoe County Health and Human Services Agency. These processes are for dependency youth in our foster program. At the onset of removal from a particular home for various reasons, abuse, neglect, unfitness, they will be placed into a legal system. That system is guided by these particular 432B guidelines due to the nature in which these children are occurring. Primarily, it's due to the confidentiality provisions that is detailed and allowed these children the protection so all of their public matters and private matters are not disclosed for all of these purposes. This 432B section has that legal basis to allow these children to go through this process in hopes of reunification with their biological parents or their guardians. However, if that process were not to be successful or that was not the correct path for that particular child, then these 432B processes take them through the termination of the parental rights and forward on to adoption services. So these particular statutes under 432B deal directly with dependency youth in our foster programs throughout the state of Nevada. To answer your question in regards to what this particular inclusion into 126 would do, it simply allows the establishment of paternity in these 432B actions for these at-risk youth and dependency youth to streamline the process and make it more efficient when moving forward with the termination and the ultimate forever family placements. Without these statutes being amended to include the paternity language into the 432B statutes, these processes require additional court hearings, they require additional motion practice, and additional publication for potential biological parents out there in the universe. With the inclusion into the already existing statute that establishes child support and other paternity actions already, we are just simply adding this particular language to this dependency section to allow the existing process through 126 to coincide with these particular cases for these youth. With this streamlined process, they will be able to avoid the additional time frame and processes through the court system. And as Ms. Howell indicated, we'll speed them up to their forever family placements in the long run and get out of our system as fast as they possibly can to ensure their health, safety, and welfare on the backside.
Thank you for that answer. And just to make sure I have it correct, so right now there may be multiple court proceedings that have to happen, and what you're trying to do is put essentially all these questions in the same court proceeding in front of one judge so that we avoid the inconvenience and time delays of potentially having multiple court proceedings, because the goal, as you stated, is to get kids placed permanently as quick as possible. So did I get that right?
Yes, you did. Thank you. Megan Lucy on behalf of Washoe County Health and Human Services. That is accurate. To be clear, I believe that all of these cases are heard by one judge throughout the state, in their various districts and counties, but it is multiple court proceedings that would have to occur under the existing law, which we are hoping to streamline moving forward. So that is correct. Thank you, Chairman. Great,
thank you. I think that makes sense. I know we've all had a long week, so trying to make it as simple as I can for everyone on the committee. I know we're struggling through the end of the week, so appreciate that. Do I have questions from committee members? If you could maybe raise your hands in front of your screens or communicate in some other fashion. Let's see, I have a couple so far. So we'll start with Assemblywoman Kasama and then Assemblywoman Krasner, and we'll go from there. So Assemblywoman Kasama, do you want to kick us off, please?
Thank you. I'm just wondering if you could walk through the amendment and, just an overview of the amendment versus the original bill and the changes and why that was made. Assemblywoman Kasama, District 2, for the record.
Megan Lucy, thank you, Chair, or through the Chair to Assembly Person. Megan Lucy on behalf of Washoe County Health and Human Services. These amendments were made to streamline the language that we proposed initially. As you will see through the initial bill, we added substantial language that mirrored the 126 code as it sat. However, upon review of the additional language and inclusion, we realized through the conversation with the many stakeholders throughout the state of Nevada that this could be done in a more efficient and less cumbersome manner. we simply took out the language that we added to 432B that existed in 126 and added that the 126 existing language then would apply to 432B actions. So in effect, all we did was take what we included out of 126 and then put the number NRS 432B to be applied in the 126 statute. So that was the purpose of our change and amendments to today's bill. Did that answer the question?
It helped. Thank you.
Yeah, I think it was well done because I got to admit, I'm pretty impressed that you were able to accomplish what you wanted by deleting most of the bill and really just adding a couple of words. So, I think committee members, if and when we process this and we have an official amendment, obviously it'll probably be a little easier to digest, but appreciate the effort to get it right. So we'll go next to Assemblywoman Krasner and then Assemblywoman Cohen. Go ahead, Assemblywoman Krasner.
Thank you, Chair Yeager. I'm not sure which presenter would like to answer this question, but several of the people here on the Judiciary Committee did not attend law school. And so just talking about particular NRS sections doesn't explain the bill to them. And I'm wondering if somebody could actually walk through the amendment and describe what they are proposing to do with this bill. Thank you.
Megan Lucy on behalf of Washoe County Health and Human Services Agency, through the chair to Assemblyman Krasner. Yes, I will be happy to walk through the bill. If everybody has that exhibit in front of them. As you can see, the majority of the first several pages have been removed from our proposed today. So if you'll scroll down to the section 12, it indicates that we're simply adding the NRS code 432B section to the establishment of the relationship between child and their parent. So in this particular section, we're simply adding the language that this adjudication of a woman's maternity is now applicable through the 432B statutes. As it stands right now, there would have had to been a separate adjudicatory hearing, a separate hearing in front of a separate court to establish that this mother, particular mother or father in this case, were those parents that needed to be terminated from the life of that child before they can be placed in their forever family. That was the purpose of that inclusion. Scrolling down to the sub 2 of that same section, that is the reverse, that the man may be established under this chapter of 432B. So what this does is it helps establish paternity through the DNA biological testing. Once there is a DNA testing that is 99.9% conclusive that that person, either mother or father, is the paternal parent to that child, that would be a legal conclusion that they are then deemed the paternal parent that would lead to the termination that would then ultimately lead to the placement through adoption in the forever family. You go down to section 13 on the following page. This allows that the 432B action be joined, it allows that a 126 action be joined with a 432B action and be initiated at any point in those proceedings. What this means is that instead of having separate court actions, which is a paternity action to establish paternity, and then a follow-up subsequent dependency action to process the child through the system, you can join these two actions into one legal hearing and have both issues heard at the same time by the same court. So as we articulated previously, this would alleviate the additional multiple court hearings and would allow the establishment of paternity, either mother or father, at the same time through the same processes of the dependency action. Scrolling down to the 2 pages later on sub 7 of section 13, this particular language is important because under the 432B statute, it's 432B sub 280, all information pertaining to this information of child welfare institutions or agencies is deemed confidential and is punishment by law. The reason why that is important in these actions is because these dependency actions have incredibly sensitive information regarding these minor children and their families. The state of Nevada has deemed that incredibly important to keep confidential as to not breach their confidentiality provisions and put these children more at risk for future issues. However, based upon the inclusion of a paternity determination in a 432B action, as we are proposing to do today, we need to have an appealable mechanism for a potential paternity action to be taken up to a higher court if that's deemed important or necessary. Therefore, with this proposed language, we are excluding the orders from the confidentiality provision that is already contained in 432B sub 280, so that the appealable methods can be utilized and these orders can be used to take it up to a higher court if it ever is become an issue. That is the purpose of excluding a particular order from those prior confidentiality provisions. A judgment or order pursuant to this chapter within a proceeding in NRS 432B is considered a final order. That is also for the particular appellate processes. You need to have it to be a final order before it can be appealed up to a higher court. So that is simply allowing the mechanism that is required through the Constitution that all actions be appealable to a higher court if it's deemed necessary. And the rest is the removal of the additional language that simply was going to shore up the language that would be consistent throughout the NRS code statutes. So the reason why the rest of it was removed was simply because it was unnecessary given the proposed amended changes. I hope that answered your question, Assemblyperson.
Yes, follow-up question, Chair Yeager, please.
Go ahead.
Thank you very much for walking through that amendment. I appreciate it. So 432B proceedings are inclusive of termination of parental rights. And I know that that's been referred to as the death penalty, the civil death penalty. I understand we want to protect children, make sure that neglected children or abused children get in their forever home. But on the opposite side, we always look at, potential unintended consequences of a bill. Are we making sure here that we're not too quickly terminating parental rights? Currently, if it has to go through a different judge or different proceedings, if there's an error or something's missed, one judge might see what another judge may have, inadvertently missed. Are we making sure we're not terminating parental rights too quickly with this? Thank you.
So Amber Howell, for the record, through the chair to the Assemblywoman, this doesn't fast track termination of parental rights quicker. We believe in 100% in what you said. Children should stay with their parents if they can. It's better if we can heal the family and keep them in their home with their biological parents and not have all of these other additional traumatic events. There are federal timeframes around when you can even move to an adoption track or termination of parental rights. You have to show active and diligent efforts through the court system, all kinds of things. It takes about 2 years of working with the family. So this doesn't speed up how quickly we terminate the parental rights. This streamlines the declaration and the paternity to make sure improve if they are the biological parent, but it doesn't. We want to give equal efforts to both sides, the child and the parents. So this won't change that because we have to give parents a good amount of time, and we want to. Because we want to try and exhaust all efforts before we go down that path, because we know that we don't take the finality minimally, and we know it's very difficult for all involved. So this will not change that.
Thank you.
We'll go next to Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. I think you covered my questions already, although I guess I do just have a statement. The section 13 sub 13 sub 7 section, the confidentiality piece, that I guess I'll just say it. I find that a bit confusing the way it's drafted, and I've heard that from another practitioner as well. So I don't know if there's a way we can kind of clarify that as you're working on the final amendment. Yeah. So I guess I'll just leave it at that. Thank you.
And this is Dagny Stapleton, Mr. Chair, to Assemblymember Cohen. We'd be happy to work on that and make sure that it's clear. And also, if it's all right, Mr. Chair, with the committee, I want to recognize Justice Seda, who I think had something to add to the last discussion.
Thank you, Dagny. Mr. Chair, to the committee, I think that the simple clarification, and first and foremost, I apologize. A bunch of lawyers presenting a bill that makes sense to them is likely to be unclear, period. So I'm going to try to help with that. Let's start with the very basics. The 432B section that is being combined with 126. 432B is the absolute guideline that every judicial officer has to follow with respect to any consideration of the care and custody of children who come into the foster side of the court. That process is not in any way affected by joining it to or taking 126 and pulling it into 432B. All of the check marks, all of the boxes that are so important to be sure that we are putting a child into the adoption track, number one, that we are protecting the rights of all parties. All of that remains exactly the same. Nothing changes. We simply bring everything about the process into one place. And I think the question about having one or two judges looking at cases or issues within those cases is important. But I will tell you that the national gold standard for taking care, and I use that term carefully, because indeed a judicial officer who sits in a 432B or a dependency court is taking care of the child. I will tell you that the national standard is that it be one judge, one family. So streamlining the process actually is a more efficient, likely to be more carefully taken in terms of considering all of the parts that have to fit together. So with one judge looking at everything up to and including this determination or establishment of paternity, it is likely to be less subject to error. And that leads me to the final question about the order in Section 13 that Assemblywoman Cohen mentioned. I think that perhaps we can clarify that language, but all that really does is we keep all of the information about the 432B proceedings protected and confidential. But this section allows for an order, the final determination, the final status. It allows for that to be taken up on appeal if necessary. So it's protecting the information that comes from the proceeding below, but allows for there to be enough information that if something needs to be put through the appellate track, that information is accessible. I hope that clears it up. 432B is your guideline. 126 is just a piece of the process that has to occur. And by this bill, we will put everything together in one place with continued consideration for the appropriate federal guidelines and the protection of all parties who are interested or affected by this determination.
Thank you, Justice Ada. I think that was helpful. And to go back to Assemblywoman Cohen's question, I'll let committee members know, because some of you are new to the committee. The amendment you have in front of you is not the official amendment that will be drafted by LCB Legal. This is essentially a conceptual amendment because it was prepared by the sponsor. So that language may look different and probably will look a little bit different when it comes out from legal in terms of the order and the confidentiality. And I'll have a chance to review that and sign off on it before we would send the bill to the floor. So I'll just make a note to make sure that that language looks okay. And we do the best we can, but obviously LCB Legal has their own processes and their own language. So it'll look different at some point. I think Assemblyman Wheeler indicated he wanted to make a comment or maybe had a question. Assemblyman Wheeler, please go ahead.
Yes, thank you, Mr. Chairman. I didn't go to law school either, but it's pretty clear to me. It looks like you're just consolidating everything. You're putting it all under one umbrella. You're speeding it up. And I want to say thank you. That's exactly what we should be doing here. So Thanks very much.
Thank you, Assemblyman Wheeler. Are there other questions from committee members? If so, if you could raise your hand in front of your camera. I think I have everyone on one screen. Okay, I don't see further questions, so I want to thank the four of you for presenting. I'll ask you to sit tight for just a moment, and we'll come back to you with concluding remarks after we take testimony. At this time, I'll open it up for testimony in support of Assembly Bill 33. Don't believe we have anyone on the Zoom with us in support. If I'm mistaken about that, if you could turn your camera on and just indicate that you'd like to testify in support. Okay, I think everyone else on Zoom is here for the next bill. So BPS, could we go to the phone lines to see if there's somebody there who'd like to testify in support of Assembly Bill 33?
Good morning. Thank you, Chair. For callers wishing to testify in support, please press *9 now to take your place in the queue. For callers wishing to testify in support of Assembly Bill 33, please press *9 now to take your place in the queue. And we will begin with caller with the last three digits of 964. Caller with the last three digits of 964, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Mary Walker, representing Lyon County, MaryWalker. Lyon County supports AB 33, and we would like to thank NACO and Washoe County for introducing the bill. Thank you, Mr. Chairman. Hope everyone's doing well.
Thank you for your testimony, Ms. Walker. We hope you're doing well as well. BPS, are there any other callers in support?
Yes, caller with the last three digits of 318, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. This is Kendra Birchie, Kendra Bertschy, with the Washoe County Public Defender's Office. Our office represents parents who are involved in the 432B actions. We support AB 33 with the conceptual amendment. I appreciate the sponsors for working with us to ensure that we strike a balance to protect the parents' constitutional rights, as well as streamline the process for all. Thank you again for allowing me to participate in those discussions, and that is my testimony. Thank you.
Thank you for your testimony, Ms. Birchie. BPS, could we take the next caller, please?
Chair, there are no further callers in support at this time.
Thank you, BPS. Before I close support, I just wanted to make clear for the record, and so committee members know that there are a couple exhibits on Nellis, one of which is a letter of support by the Clark County Department of Administrative Services, and then I don't know if we'll hear from them, but there's also a statement from Carson City that they are removing their proposed fiscal note based on the amendment to the bill. So I will close supportive testimony. I'll now open it up for opposition testimony. I don't think we have anybody on the Zoom in opposition. BPS, could we go to the phones to see if there's anybody who'd like to give opposition testimony, please?
Yes, thank you. For callers wishing to testify in opposition of Assembly Bill 33, please press *9 now to take your place in the queue. For callers wishing to testify in opposition in Assembly Bill 33, please press *9 now to take your place in the queue. Chair, there are no callers in opposition.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony on Assembly Bill 33. We don't have anyone on the Zoom with us to provide neutral testimony. BPS, can we go to the phones to see if there's somebody there, please?
Thank you. For callers wishing to provide testimony in neutral of Assembly Bill 33, please press star 9 now to take your place in the queue. For callers in neutral of Assembly Bill 33, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers in neutral at this time.
Thank you, BPS. Appreciate it. I will close neutral testimony. We'll now come back for concluding remarks. Ms. Stapleton, others on the Zoom with us, if you want to make some concluding remarks, now would be the time.
Thank you, Chair Yeager, Dagny Stapleton for the record. Thanks again for hearing this committee. Thanks to the committee members, and thank you so much for the questions and the discussion. Please follow up with us if there's additional questions or clarifications that we can offer offline. I did want to note, as the chair mentioned, that there were some fiscal notes submitted on the bill from counties, and both of the counties with fiscal notes who noted an impact did submit letters that are on Nellis indicating that with the amendment, their fiscal impacts, their concerns had been alleviated. And I believe we did have a representative from Clark County who was ready to provide testimony and support, but there were technical difficulties. So on behalf of our members are in support of this issue, and Carson City and Clark County specifically are good on the fiscal note, on the fiscal impact portion of the bill. And finally, again, I just want to offer my thanks and give Director Howell or Justice Seda an opportunity also to provide any closing remarks. Thank you, Mr. Chair.
Thank you. Before we do that, I wanted to note I did have a conversation with Clark County yesterday, and they did indicate, in fact, that they were supportive of the amendment. I think it was Mr. Ortiz who maybe was going to be on the line. So if we could just note for the record that I at least had that conversation, and they told me the same. So we apologize, Mr. Ortiz, for the technical issues. Seems to happen to us at least once a day, but we're doing the best we can with all this virtual world. And so let's go next. Justice Seda or Ms. Howell, do one of you want to provide, or both of you want to provide comments? Let's see. Justice Seda unmuted first, so you can go next.
To the chair and to the members of the committee, I only want to thank you most sincerely, personally and professionally, on behalf of your time and your energy that you will put into this bill. Thank you for hearing us this morning. Of course, I would urge that you consider it as a due pass when it is properly amended. Thank you so much.
Ms. Howell, please go ahead.
Amber Howell for the record. Just wanted to thank the committee for having a great discussion about this important issue and all the support that we can get to get children in their forever home when it's time to do that. I appreciate all of your time today.
Hey, thank you so much to the four of you for spending some of your Friday morning with us and for presenting Assembly Bill 33. We certainly appreciate it and hope you have a great rest of the day. With that hearing behind us, I will close the hearing on Assembly Bill 33. Members will move along to our second bill on the agenda, and I will now formally open the hearing on Assembly Bill 182. Assembly Bill 182 revises the elements of the crime of advancing prostitution, and members of the committee, members who might, or individuals who may be watching on the public, likewise wanted to let you know that there is a proposed amendment, I believe, on Nellis. Let me just check to make sure. Or maybe there is not. I can't remember. So I'll leave it at that. But I want to welcome back to the committee Assemblywoman Tolles, who was on the committee the last couple of sessions. We certainly miss you here in the Assembly Judiciary Committee, and we're happy to have you back this morning. So we'll give you a chance to present Assembly Bill 182, and then I'm sure we'll have some questions. So welcome back, and please go ahead when you're ready.
Thank you so much. Good morning, Mr. Chair, Vice Chair Wynn, and members of this esteemed committee. I am Jill Tolles, representing Assembly District 25, here to bring forward AB 182. And as a point of personal privilege, I do want to say I miss you. I miss this committee. I served on Judiciary for 2 terms, and I know firsthand just how hard working this committee is and how you tackle so many complex issues, so many issues that often carry so much passion and emotion and truly impact people's lives. And I just want to say that I recognize that you do the state of Nevada a great service to serve on this committee and to be willing to dive into those difficult issues. And so I just want to start with backing up a little bit with, since I'm not on this committee and we haven't had a chance to hear each other's stories as much as in the past, I want to share just a little bit of my journey into this particular topic and into the legislature as well. My journey into legislative work actually was in part as an advocate for child sexual abuse prevention. And over the years, that led me to learn more about issues of human trafficking in our state and just how prevalent these issues are. And over the years, I've had the opportunity and the privilege of working with many stakeholders from victim advocacy groups, the Attorney General's office, law enforcement, district attorneys, public defenders, interest groups, individuals, the business community, and including the Nevada Resort Association. And I'm just so incredibly grateful for the work of all these stakeholders in providing input on all legislation that we look at in regards to these issues. And over the years, I have had the privilege of both presenting and supporting legislation addressing issues of sexual abuse, assault, and human trafficking. And that actually also led to starting a Northern Nevada Sex Trafficking Task Force with the mayor of the city of Reno, Hillary Sheevy, which engages in Northern Nevada, all of those stakeholders. And anytime that we talk about this issue, I often look at it through three different components. The demand side, addressing the buyers, traffickers, addressing those who exploit individuals and abuse them, and then the victims. And in everything we do and anytime we have this conversation, I believe it's incredibly important that we always take a victim-centered approach. And again, I've had the privilege of supporting and presenting information or legislation that has addressed each of these aspects. But this particular bill addresses legislation that this body successfully passed in the 2019 session, AB 166, that very narrowly, specifically addressed individuals who were using their businesses as a front for sex trafficking. And so I'd like to present to you AB 182, which revises the elements of previous legislation relating to advancing prostitution. So last session, the legislature passed AB 166, which created the definition for advancing prostitution and established penalties for the crime. In response to an increase in cases involving individuals who knowingly used their businesses as a front to exploit individuals involving sex trafficking. Since its successful passage in 2019, I was approached to bring forward this legislation by the Southern Nevada Human Trafficking Task Force to clarify some of the language in NRS 201.395 based on input from the Attorney General's office, law enforcement, criminal justice representatives, victims advocates, and businesses. And generally speaking, AB 182 refines the enforcement language of NRS 201.395 while maintaining protections for businesses not knowingly engaged in this illegal activity. With your permission, Mr. Chair, I'd like to briefly go through the highlights of AB 182.
That'd be great. Thank you.
Thank you. So, and I do want to clarify, there is no amendment as of yet for this bill. And in great part because of all the stakeholder input, I hope ahead of time to get the language just right. So section 1.1 clarifies an individual knows these crimes are occurring if they received written notice by law enforcement. Section 1.1A also removes the section pertaining to involuntary servitude because it's a category B felony and therefore a higher standard than the crime of advancing prostitution, which is only a category C felony. Section 1.3 removes the requirement that law enforcement must notify the individual 3 times and reduces it to 1 written notice because law enforcement couldn't take action until 3 known incidents, which of course prolonged being able to help those victims and became too resource intensive. Section 1.3 removes the abatement step of promoting ongoing education about such illegal prostitution for employees because it created too large of a loophole for a business to simply hang a poster as a defense for taking steps to abate prostitution. So Chair Yeager, that concludes my presentation of AB 182, and with your permission, I'd like to acknowledge that we have Nicole Riley, Domestic Violence Ombudsman for the Office of the Attorney General, Lieutenant Corey Salferino with the Washoe County Sheriff's Office, Sergeant Scott Smith with the HEAT Team, Human Exploitation and Trafficking Unit, Jenny Noble with the Washoe County DA, and I believe Lieutenant Nate Chio with Las Vegas Metro Police Department, available to answer any technical questions as they come up from the committee. Thank you.
Great. Thank you so much, Assemblywoman Toll. So I think what we'll do, committee, we obviously have a lot of folks with us on the Zoom, and I take it that many of them will probably provide testimony in support, but they're also here for questions. So I think what we'll do is take questions first, realizing that we may be hearing answers from some folks who haven't had a chance to speak on the bill yet, but I think that probably makes the most sense. And so I'll start with one just while I have the bill open, and you know, this may be one for you, Assemblywoman, or maybe one for law enforcement. And so the question really is, you know, the trigger here is if a business receives written notice from a law enforcement agency that illegal prostitution is happening on the premises. And my question is, what would that written notice look like? Is that a copy of a police report, or how do we envision, I guess, if that's happening now, in what manner is that written notification being given? Or if it's not happening, how do we envision that would happen?
Thank you. And I do have the Washoe HEAT team here available to answer some of those technical questions. So I will turn it over to them.
Chair Yeager, members of the committee, Corey Salferino representing the Washoe County Sheriff's Office, and on behalf of the HEAT team, Sergeant Scott Smith, Detective Sergeant over our Human Exploitation and Trafficking team. What we envision here, sir, is after a formal investigation where we identified that this activity is happening on the premises, that a certified letter with a copy of the police report and explicit notification of the crime that is occurring would be rendered to that business establishment, providing a record of notification versus just happenstance or perhaps 3 different ones. So we believe that this language is much more concise and provides us the ability to provide that written notification upon investigation and determining that these activities are taking place on the premises.
Thank you. That's very helpful. Committee members, any questions based on the bill in front of you, Assembly Bill 182? If you could raise your hand if you have any questions at this moment. I see Assemblywoman Marzola, so let's go there first.
Thank you, Chair, and thank you for the presentation. My question is to Section 1, subsection 1A, to where the words knows or should have known, the words or should have known is deleted. And I'm wondering why, because as I read it, leaving that there would help in a greater scale, right? So I'm wondering what the thought process was in taking that portion out.
Thank you so much for the question, Chair Yeager, through you to Assemblymember Marzola. So that was based on legal's interpretation, and I do agree with it, that essentially once you receive notification, we have proof of receipt of notification, that that determines that that individual owning that business does have knowledge. You're correct that should have known would broaden it, but we wanted to be very cautious about making sure that this didn't unwittingly apply to business owners who did not have knowledge.
Thank you, Assemblywoman Toles. Thank you, Chair.
You're welcome. We'll go next to Assemblywoman Cohen and then Vice Chair Wynn.
Thank you, and it's good to see you, Assemblywoman. I have a question about the notification piece and what that covers. So if, for instance, you have a situation where you have a laundromat, the owner of the laundromat gets notice, and so he kind of shuffles out the people that are involved, and then a week later, 6 months later, new people come in and start kind of using his facility. And I'm sorry. Yeah. So does that notice that he got previously count against him as having notice, or is it each individual situation that he gets notice of each individual situation as opposed to just a broad notice that, yeah, there's been prostitution happening at your facility?
Thank you so much for that question. It's a great clarifying question. And again, our intent and goal here is to truly help create a process by which we can identify who is knowingly and actively engaging in this activity of exploiting, abusing, and trafficking victims versus somebody who is not. So this puts forth that, in each instance, it's a separate instance. It's followed by receipt of notice and then cooperation with law enforcement to take steps to abate. But there is no graduating penalties or graduation of incidents. It is truly to clarify that process. And I'm happy to open up to the district attorney's office, the attorney general's office, or to law enforcement if they'd like to add clarification to that answer.
Good morning, Jennifer Noble on behalf of the Nevada District Attorneys Association and the District Attorney's Office. As I read the language of the bill, it would be that each notice by law enforcement would regard a discrete set of transaction or occurrences that led them to give the notice in the first place. And so if a property owner takes action with respect to that notice, in terms of the abatement that is listed, I believe in section 3 of the bill, A through C, that would satisfy it for that occurrence. If a new set of folks move in and they're engaged in the same type of activity, as I read the current language, another notice would need to be given by law enforcement specific to those persons and their activities.
Thank you for that. And I guess I just want to, I don't know, I just want to make sure we play out all the scenarios, because what if it's the same pimp, but it's different women that he's got working for him? Like, what happens then?
Jennifer Noble, for the record, I think that's an excellent question, Assemblywoman Cohen. As usual, you think of a lot of different scenarios, and it's very helpful to the record. If you have, for example, the same pimp but different women, it's still different, or men, it's still different individuals engaging in the prohibited conduct on the property owner's property. So I think the same analogy would apply, where you would need to have a subsequent notice by law enforcement.
Thank you.
Thank you, Assemblywoman. We'll go next to Vice Chair Cohen and then Assemblywoman Hanson.
Now you're just messing with us.
I actually did mess that one up, so I'm sorry, Vice Chair Wynn. It's Friday, the brain is not working, so we'll go to Vice Chair Wynn and then Assemblywoman Hanson. I'm sorry about that.
That's like 3 times in the last 24 hours. That's okay. Thank you. Rochelle Wynn for the record. It's good to see you, Assemblywoman Toles. I know that a lot of this was clarification, obviously, from last session, and some cleanup and clarification. I don't know. I received it pretty late last night. There was a letter from UNLV professor Barbara Brentz. I don't know if you have had the opportunity to look at some of her concerns regarding Assembly Bill 182, But one of the ones that I saw in there, which was kind of interesting, she had a couple of interesting points, and I was wondering if you could address some of that. One of them was the policy that Assembly Bill 182 punishes the property owner for purportedly allowing prostitution, which is a misdemeanor crime, and it's punishable for the owner as a felony. And so not all like prostitution involves sex trafficking. Is there any kind of clarification that we might be able to do? And I'm wondering how like some of these retail association and businesses feel about law enforcement kind of having unlimited access to their facilities to go undercover and surveil for a felony threat for misdemeanor crimes in this area. So I was wondering what kind of conversations have taken place with the stakeholders. Obviously, I know that, you know, I just received this last night and read it this morning, so I'm sure you have hopefully had the opportunity to kind of, you know, take that all in, but I was wondering if you had any thoughts on those two subjects.
Thank you so much for the question through you, Chair Yeager, to Vice Chair Wynn. I do appreciate, and I don't have that letter in front of me, but I do appreciate, first of all, conversations and input from all the stakeholders. And I'd like to acknowledge for a moment that that this legislation is, you know, intended to be very narrow in its scope and in its application. And I would encourage the individuals in this committee to perhaps go back to AB 166, because if I recall, it was quite a lengthy hearing, I think about 2.5 hours with, I believe, about a 40-minute presentation presenting cases, which brought forward the justification for why we needed something specifically in statute to be able to charge individuals who were knowingly engaging in this activity. But it's important to acknowledge that this is a much broader, complex discussion overall in our state around how we address holistically all of these issues. And I do appreciate stakeholders who continue to engage in those discussions, even outside of the scope of what this legislation hopes to accomplish. And I support those discussions continuing on the broader holistic scale. I want to reference back specifically to AB 166 and something that we made very clear on the record when we first presented this legislation that I want to quote again so that it's clear on the record today. And that was when I presented AB 166, I presented it with Director Chuck Calloway, and he ended his closing comments with this, and I echo them, that I want to emphasize that this bill is not directed at victims or sex workers. It is directed at business owners who are facilitating and trafficking victims. And I also want to acknowledge that I myself and my husband are commercial property owners. We have 120 tenants in downtown and midtown Reno, including massage parlors, tattoo parlors, nail salons. I don't believe, Assemblywoman Cohen, that we have any laundromats in our portfolio, but I do appreciate you always asking questions in regards to how this might be applied to various business settings. And so as a property owner myself of commercial properties with tenants, we read this language and reached out to others in the business community to make sure that it was narrowly tailored in such a way, which is why we added that it was receipt of written notice and that it involves cooperating with law enforcement. I'll let law enforcement step in and share a little bit more about their current process and how we've seen this play out in recent years. The last thing I'd like to add, though, is that we have done a tremendous amount of work over the interim directly in response to concerns raised by advocates and stakeholders around taking a trauma-informed approach, a victim-centered approach with law enforcement when they engage with these businesses and when they engage with individuals in these activities. That, again, that intent is not to target or to arrest the victims or the workers, but to really narrowly define and identify those individuals knowingly exploiting, abusing, and trafficking through their businesses.
Did you want to add anything to that, Mr. Solferino?
Yes, Chairman Yeager, Vice Chair Nguyen, members of the committee, Corey Solferino, again representing the Washoe County Sheriff's Office. And just to echo what Assemblywoman Toll said, she's been a champion for human trafficking in Northern Nevada to address the issue, to bring education, to bring aggressive prosecution, to take that victim-centered approach. Unfortunately, we were kind of late to the game. We've been listening to the legislative body for the last several sessions and the importance with human trafficking and forming our own task force under her experience and tutelage and bringing all the stakeholders together from the casino industry, from the Regional Transportation Commission, law enforcement, the Public Defender's Office, the DA's office, the ACLU, bringing everybody in the same room to address these problems. And the best practices and evidence-based solutions to ending and combating human trafficking are aggressive prosecution, taking that victim-centered approach, and reducing demand. And we believe by holding business owners accountable for these types of instances when they occur, we can champion that endeavor. And one of the things that I do want to say just before I conclude my comments, at least on this piece, is that the education campaign in this is huge. This is not a victimless crime. A lot of these women and men are brainwashed. They're taken as adolescents. They're a vulnerable population. They don't know what they don't know, unfortunately. So some of the ways that we try to reach out to them and we try to get them to trust law enforcement is a very extensive process. And, Detective Smith and I were talking about a juvenile that we've been going after for the last several months that we've recovered 4 times as a 14-year-old, now 16-year-old over the course of several different states and jurisdictions, trying to get her the services that she needs to recover. All this is an accountability piece for business owners after a thoughtful investigation where we have identified that this problem is occurring on their premises. And in Northern Nevada, in the year that we've been operating under the Human Exploitation and Trafficking team, we have not sent a formalized letter to anyone yet. We have not identified those entities. A lot of what we're doing right now is doing the reverse John operations where we are targeting those pimps. We are targeting those Johns. Once we get past COVID and we continue on this endeavor and we start identifying those businesses, be happy to share our process with you. We're, like I said, we're a little late to the game, and Metro's been championing this effort for several years. We don't want to steal their thunder, but we want to address a crime that is running prevalent in Northern Nevada as well as the rest of the state.
Thank you. And Mr. Chair, if I could add just very technically, because I do think it's important to get this clear for the record in response to the Vice Chair Nguyen's question. If you notice in Section 3 under the steps to abate, we have 3 steps there, and it's very important to note that it's an or, not an and. So business owners do not need to meet the standard of all 3 of those steps. They can meet any one of those steps in order to demonstrate that they are taking steps to abate and not guilty of this Category C felony brought forth in this chapter. I hope that helps to clarify for the record and answers Vice Chair Nguyen's question.
Vice Chair Nguyen, did that answer your question, or did you have any follow-ups?
Okay, that answered my question, and I can follow up with the bill sponsor if I have any further questions. But I would love to, after you have an opportunity to review that documentation, if we could revisit some of those issues.
Absolutely, I am always one for having the much broader conversations, and I appreciate input from everyone involved.
Up next, we have Assemblywoman Hanson and then Assemblyman Ohrenlicker. Assemblywoman Hanson, please go ahead.
Thank you, Chair. Good morning. Assemblywoman Tolles, it's good to see you and appreciate the presenters that are here. I'm just wondering if it would be a good idea. We certainly always want to be careful with legislation about protecting due process for individuals. But I remember as my first session in 2019 and first time on this committee, when the other legislation came through, I was really surprised at what kind of a problem we have with some businesses being fronts for this sort of activity. So perhaps law enforcement could give us an overview, especially for those who are new, of some real world examples that are occurring in our communities, just to the degree that these fronts are so insidious or so under the radar, and that this kind of legislation could be helpful with. So it's just some real world examples.
Thank you for that question, Assemblywoman Hanson, through you, Chair Yeager. I'll just start briefly with, it just so happened in 2019 when we brought forward this legislation, there was quite a national focus, specifically on illicit massage parlors that were very specifically using their businesses to traffic individuals. We had a number of cases with photographic evidence and some pretty harrowing stories of how individuals were being trafficked. And it wasn't just in massage parlors. It was also, we had a case of a tax prep service that, as I testified in 2019, didn't have a computer or a calculator to be found, but 8 beds and 11 Asian women hiding in a back storage room. We had testimony of shoes being locked into locked away cabinets, IDs being taken, threats of physical violence against the victims and their family members, and truly some of the worst human rights violations you could imagine. I'll let our law enforcement add if they would like to anything to that.
Chair Yeager, members of the committee, Corey Solferino again for the record. As I said, we were a little late to the game as far as getting our unit stood up. This was born out of the street enforcement team, a traditional vice narcotics unit. We identified the need. Sheriff Balaam, Chief Soto from the Reno Police Department, Chief Crawforth from the Sparks Police Department understood that this was an issue that was coming to prominence in Northern Nevada, and dedicated detectives, detective sergeants to that goal. I'm happy to report that over the next 6 months, we do anticipate adding an additional Washoe County Sheriff's Office detective, an additional Sparks PD detective, and a University of Nevada Reno police detective to further these efforts. A lot of our operations at this point have been on a smaller scale, not targeting these businesses yet. Historically, we do look at massage parlors and some of the other business fronts that are operating under different covers of business licensing and then performing these sex trades behind. We have not identified those locations in Northern Nevada. As we continue to grow our unit and seek funding for advanced operations, that's what we will bring and report to this body. Las Vegas has led the charge on this for several years and has obviously more examples. We can speak from a historical context, but we haven't gotten to that investigative process in the North just yet.
If I may add, Chair Yeager as well, and members of the committee, I do believe that we have a number of individuals signed in for support who may be also able to answer that question in their testimony.
Thank you so much.
Thank you. We'll go next to Assemblyman Orentlicker.
Thank you, Mr. Chair. David Orentlicker, Assembly District 20 for the record. And thank you, Assemblywoman Tolles, for all of your so important work against human trafficking. As you point out, it's such a serious problem. And I applaud you for championing Assembly Bill 166 in 2019 and also trying to refine it and do some cleanup. And a number of the provisions are very good for doing that, like changing the knows or should know to knows. I think that's an important way to refine the bill. But I'm not as clear on, you've described this as a narrow approach to address the human trafficking problem. And that was the idea. And once in 2019, and again today, you've talked about focusing this on trafficking. But by deleting 1B on page 2, lines 7 through 9, the involuntary servitude part, and I understand your concern about the conflict between Class B and Class C felony, and it seems to me there might be a simpler and narrower way to fix that, because by deleting it entirely, it's no longer narrowly focused on human trafficking. Now, this picks up the landlord who rents an apartment to a consensual sex worker, and one of the implications would be for a lot of landlords, it's not worth getting caught up in this statute, and maybe I shouldn't even rent. If I think this person's a consensual sex worker, I shouldn't lease an apartment. And the other thing that we know when we broaden our statutes beyond the human trafficking, or we've got a pandering and sex trafficking provisions, which go after people who induce or coerce sex works, which we should be very aggressively going after. Now this statute broadens it to any kind of prostitution. And that means, and when we see that being enforced, we tend to see it in a racially disparate way. And so it seems like you've taken a very narrow approach to it and now just opened up the waterfront. And it's going to have a lot of implications that it doesn't seem like you're intending with your focus on the trafficking problem.
Chair Yeager, to Assemblyman Lichter, and I appreciate your thoughtfulness in regards to this topic, and not wanting to totally rehear the original bill. Maybe I left out a few clarifications that I included. So if I may go back to some of the things that we had on record in AB 166 to address yours and perhaps some other concerns that might help to provide a little bit of the context. I want to point out that this is under NRS Chapter 201, and that the language falls under the exception that is except as otherwise authorized by law, making it explicitly clear for the record that except as otherwise authorized by law does not impact legal sex work in brothels in our state. And then also, I was very sensitive to making sure that this was captured under the protections for victims of human trafficking. And so I want to point out that in NRS 201.303, it states that for a victim of sex trafficking or facilitating sex trafficking, there is a rebuttable presumption that the person who committed the violation acted under duress, and that would also be included. And again, making sure that we always keep victims in mind. And the original bill actually only had this new law in regards to advancing prostitution. We later amended the involuntary servitude later on in the process. After I heard the testimony, I thought that perhaps it would be good to also include involuntary servitude. However, again, it was pointed out to me after we passed that legislation in 2019 that it was not a good match for this chapter, since it is a higher standard to prove at a Category B felony level and didn't necessarily fall in line with a Category C felony chapter. And so the goal, the original language did not include involuntary servitude. The original language always fell within this chapter where we had the applicable laws to address this issue. I also asked Washoe County DA Jennifer Noble, to Assistant DA, to comment on this from a legal perspective as well, to answer that question, but hopefully that provides a little bit more of a backdrop for you.
Jennifer Noble, for the record, through you, Mr. Chair, to Assemblyman Ohrenlicker. I think, Assemblyman, you've hit on a question, really is the conduct that we think of under NRS Chapter 200, I think, .300, which talks about pandering, which is inducing someone to be a prostitute, a pimp, basically, and sex trafficking, which we know is the coercing, recruiting individuals to engage in prostitution under some sort of threat or duress. So that type of activity, when it's being knowingly allowed on a premises, is something that we need to be able to capture, because law enforcement has to have the ability to reduce the demand for the commercial sex trade. And whether landlords like it or not, they are part of this ecosystem. And so their cooperation is critical. So if a property owner is simply turning a blind eye to what's going on, but they have no notice, they don't have to be worried about any criminal liability. It's only after they receive this certified letter, this written notice that this is going on, that they have an obligation to undertake one of the 3 different types of abatement that's in section 1A, or I'm sorry, section 3A through C of the bill. That could be as simple as filing an online police report. So it's not terribly onerous on the property owner. And while I certainly understand what you're saying, we do need to confront the fact that property owners are part of this ecosystem, and we cannot combat this issue without their cooperation.
Thank you for that explanation. And Chair Yeager, if I may just add, the whole genesis of this need for legislation in the first place was because when law enforcement identified that these activities were occurring in these very specific instances, we did not have a statute by which to charge the individual and the owner. So they could hide behind the defense that, well, these individuals are independent contractors, I can't be held liable. And that was the reasoning behind why we needed this statute. If you could imagine how incredibly frustrating that would be to know that somebody is actively engaging in these abusive and exploitive activities and not having anything in the law to be able to charge them with. That was the purpose of bringing forward this bill, and again to narrow its application in its implementation and enforcement.
Mr. Chair.
Please go ahead.
Thank you, David Orentlicker, Assembly District 20 for the record. I understand the goal of making sure that we capture the landlords who turn a blind eye to human trafficking or coercion or inducement or any of the concerns that we've prohibited. And that's important. But the statute does it in a way that goes beyond those situations. It's no longer just the coercion or the inducement or the trafficking, sex or human trafficking, all those important problems that we're addressing. Now it covers the landlord who leases an apartment to a illegal but consensual sex worker who's not being coerced, not being trafficked. And now, as I say, even they're going to be very reluctant to rent an apartment, even though, yes, I can just file a form, but they're also facing a Class C felony. It's probably not worth it. And again, it's going to happen in a racially disparate way.
So I think we'll leave that question there. Maybe there's a further discussion to be had on that point, but I think I understand where both Assemblyman Orentlicker and Assemblywoman Tolles are coming from on that particular question. So I would invite the two of you to perhaps talk about that in a little more detail after the meeting. Do we have other questions from committee members? Got you all on my screen. So this is last call for questions before we start taking testimony. Assemblyman Wheeler, please go ahead.
Thank you, Mr. Chair. The way I read this, I see that this takes the people who don't want to get involved and gets them involved. It takes the people that are already involved and want to be involved and actually creates a punishment for those people. So I think that's kind of the way that I would simplify this. Someone rents an apartment, for instance, to someone not knowing what they're doing, and then finds out later that, they're using their apartment for, an illicit behavior, and says, well, I don't really want to get involved in this. At that point, they have a reason here to get involved. Am I correct, Assemblywoman?
Again, it's just to clearly establish the record of a written notice, and then a way for somebody to distinguish if they are knowingly involved with this. Then we have a statute that we can apply to charge them, and if they are not knowingly involved, then they have steps that they can utilize to work with law enforcement to ensure that that the victims are protected and perpetrators are charged appropriately. And I'd like to just bring us back to, again, this is one piece of a very lengthy chapters regarding all of these crimes, and that in no way does it replace other charges for somebody who would fall under many of the other statutes. And then last, I just always want to keep coming back to the victim-centered approach and the fact that we have some great discussions in other bills in this legislative session that I look forward to continuing to engage in, to avoid what I hear is a concern here, where we might be in a situation where we end up, evicting victims and individuals who are disparately targeted, victimized in situations of vulnerability. That is not at all the intent of this legislation. And as I said back in 2019, and I'll say again today, I believe wholeheartedly that other efforts that we currently have existing in statute, as well as additional ongoing discussions about how we ensure that we provide resources and support so that we are truly targeting the individuals that we want to be targeting here, is part of that overall holistic conversation. So thank you again for all your questions. Thanks for the opportunity to clarify the intent of this law in this hearing today. And I look forward to continuing having ongoing conversations. And if there are additional language or wording that we can consider, I am always open to that discussion. Thank you.
Any further questions from committee members? I'm not seeing any hands raised. So Assemblywoman Tolles, I want to thank you for presenting. We'll ask you if you're able to sit tight and have some concluding remarks, but I also know that you're probably supposed to be in another meeting right now. So if you have to go over there, we will not hold that against you. So what I'm going to do now is go to supportive testimony on Assembly Bill 182. And I'm assuming the folks who are with us here on the Zoom would like to provide supporting testimony. So what I'm going to do is just kind of call each of you out individually. So hopefully this will be orderly. Ms. Riley, why don't we start with you? If you'd like to provide testimony in support, now would be the time. Thank you.
Great. Thank you so much, Chair and committee members. For the record, Nicole Riley, Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking at the Nevada Office of the Attorney General. And I am here today on behalf of Attorney General Aaron Ford to testify in support of this bill. Thank you.
Thank you so much for your testimony. Why don't we go next to Ms. Noble, please?
Thank you, Mr. Chair. Jennifer Noble on behalf of the Nevada District Attorneys Association and the Washoe County District Attorney's Office. Assembly Bill 182 is an important step in refining our ability in our toolbox to target those who are willfully allowing or encouraging sexual exploitation on their premises. It is a victim-centered approach that ensures that no property owner or business owner will be caught up in a criminal charge unless they are willfully not cooperating with the police and not reporting the activity. We'd like to thank Assemblywoman Tolles for her tireless efforts to help victims of sexual exploitation throughout Nevada with this legislation.
Thank you, Ms. Noble. Appreciate that testimony. Why don't we go next to Washoe County Sheriff's Office for any testimony and support?
Chairman Yeager, members of the committee, Corey Solferino representing the Washoe County Sheriff's Office. We want to thank Assemblywoman Tolles, all the co-sponsors and primary sponsors of this bill, for their tireless efforts. This is not just something that we address during legislative seasons. This is something that we address through the interim and our champion now in Northern Nevada on a daily basis. So for those efforts, we applaud all the stakeholders for coming together and really trying to do a community-centered, victim-centered approach on these pandemics that are in our area. We encourage your support of AB 182. I don't need to belabor you by reading my testimony. It's part of the record. I sent it to the secretary this morning. So I just want to thank all of you for your careful consideration and encourage your support of AB 182. Thank you.
Thank you for your testimony. And we have Mr. Vasiliadis with us as well. If you'd like to give your testimony, please go ahead.
Yes, Mr. Chair, thank you. Good morning, members of the committee. Nick Vasiliadis with the Nevada Resort Association for the record. We are here in support of this bill and would like to thank the sponsor for working with all the interested stakeholders to make sure we got this bill in a place that it was effective without, any unintended consequences that could hurt any business owners. So we appreciate all the work from all the other existing stakeholders and love to see bills that evolve over sessions to develop great policy for the state. Thank you.
Thank you, Mr. Vasiliadis. I think that takes care of everyone we have on the Zoom with us. So BPS, could we go to the phone lines now and see if there's anybody there who would like to testify in support?
Thank you, Chair. For callers wishing to testify in support of Assembly Bill 182, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 196. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Chairman Yeager and members of the committee. This is Eric Spratley, ERIC-SPRATLEY, representing the Nevada Sheriffs and Chiefs Association. Ditto to all the aforementioned comments. We support the bill. Thank you.
Thank you for your testimony, Mr. Spratley. BPS, could we take the next caller, please?
Caller with the last 3 digits of 355. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Yes, Chairman Yeager and members of the Assembly Judiciary Committee. My name is Gary Landry, G-A-R-Y-L-A-N-D-R-Y. I'm the Executive Director of the Nevada State Board of Cosmetology. I'm speaking in support of Assembly Bill 182. We've had a few cases of prostitution within our licensees over the past several years. We had problems until Assemblywoman Tolles introduced legislation in 2019 to make it easier to prosecute those cases. This bill is another way that will help us when we run into prostitution. By holding the people who run the salons to be responsible for ensuring prostitution is not being allowed in the salons, that will help us in getting prostitution out of the cosmetology profession. Therefore, I and the Nevada State Board of Cosmetology supports Assembly Bill 182.
Thank you for your testimony, Mr. Landry. BPS, let's take the next caller, please.
Next caller with the last 3 digits of 916. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. This is Lieutenant Nate Chio. First name is N-A-T-E. SNCHIO from the Las Vegas Metropolitan Police Department, Special Investigations Section. My section has been involved in numerous cases involving illegal fronts of prostitution being conducted in legitimate businesses. What I can say from our practical experience over the last several years is there's not been one instance to my recollection where there's been a legitimate property or business owner who finds out that prostitution is being conducted at their business that doesn't take immediate action as a responsible business owner. There's only those businesses that are continuously involved in the sexual exploitation of the prostitutes that this bill, I believe, targets. I can give real world examples if you would like.
Lieutenant Chio, I don't think we need real world examples. I would commend to the committee, if you're interested in that, you could go back and watch last session's hearing where there were some given there. But Lieutenant Chio wanted to make sure you didn't have any other remarks before we moved on.
No, sir. I just been listening to the meeting, and I know that there was one lady that wanted some real world examples, so I'm here to provide that if necessary. Other than that, we do support this legislation.
Thank you so much, Lieutenant Chio, and I would invite members to reach out or to look at last session's hearing for more details about what we're talking about here. BPS, could we see if there are any more callers in support, please?
Thank you. Next caller with the last 3 digits of 047. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. My name is Lauren Boytel, Lauren Boitel, and I'm the Executive Director of Impact NV and the Chair of the Nevada Policy Council on Human Trafficking, which is a diverse cross-section of community leaders and survivors from the public, private, and NGO sectors coming together to pursue collaborative, long-term systemic strategies to decrease sex trafficking in our state. On behalf of the Policy Council, we support AB 182. We think it's very important to reduce the burden on law enforcement to prosecute truly bad actors who are hiding behind business licenses to exploit vulnerable women and children, and to support victims and get them out of their trafficking situations. And we think it's an important step to continue Nevada's leadership in advancing good policies and state laws that combat human trafficking. So we are in support and appreciate Assemblywoman Toll's leadership in this area. Thank you.
Thank you for your testimony, Ms. Boytel. BPS, are there other callers in support?
Yes, Chair, thank you. We will take the next caller with the last 3 digits of 700. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Brian Walker, BRYANWACHTER. I'm with the Retail Association of Nevada, and we want to thank the sponsor for continuing to tackle this problem and to bring needed solutions. We want all business owners and businesses in the state, especially our retailers, to act within the law, and this notification will allow them to be better partners moving forward, and we appreciate and support this effort.
Thank you for your testimony, Mr. Wachter. BPS, let's take the next caller, please.
We will take call-in user 4. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Thank you, Mr. Chairman, members of the committee. This is Chuck Calloway, CALLAWAY, Las Vegas Metropolitan Police Department Director of Intergovernmental Services. I know Lieutenant Chio expressed our support, and I'm not trying to take 2 bites of the apple, but I thought it was important to just clarify a couple of issues. I did co-present with Assemblywoman Toll's last legislative session on this very important piece of legislation that now she is making an effort to tighten up and clean up some of the language, and this is very important. I just wanted to state that this is not aimed at legitimate businesses. This is aimed at human traffickers who are using businesses as a front to profit off of these victims. And, when we have those cases, like she mentioned, of tax preparation services that have rooms in the back with cots and cash counting machines, when we have hotels that rent rooms by the hour and they have bowls of condoms in the front where you check in, and they know full well that women are being trafficked out of these rooms. And then when law enforcement steps in, the victims of trafficking are afraid to say anything. They're afraid to come forward. Many times they're illegal immigrants, and they're afraid that they're going to be deported back to their country of origin, and they don't want to go against the business owner, and these business owners are profiting off of this. This is not legitimate businesses that we're targeting here. It is traffickers. So with that, Mr. Chairman, I appreciate the committee's consideration of this bill. Thank you.
Thank you for your testimony, Mr. Calloway. BPS, are there other callers in support?
For any callers wishing to testify in support of Assembly Bill 182, please press star 9 now to take your place in the queue. And we will go with the second caller with the last 3 digits of 700. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Yeager and members of the committee. My name is Kim Yeager, KIMYAEGER, and I am the Director of Marketing and Member Relations for the Nevada Trucking Association. On behalf of the Trucking Association and Truckers Against Trafficking, I am here to testify in support of AB 182. The Nevada Trucking Association has made it a priority to help educate not only our members, with the public, law enforcement, and related industries such as the casinos, transit, and real estate on how to identify the signs of victims being trafficked and the steps to take to help rescue the victims. Our efforts began back in 2012 when we launched Truckers Against Trafficking here in the state of Nevada and partnered with the Nevada's then Attorney General Catherine Cortez Masto in a campaign to educate law enforcement and the public about sex and human trafficking within our state, one of the first in the country to successfully adopt an anti-human trafficking program. Through our continued efforts to help combat this horrific crime, we provide an in-depth law enforcement training through Truckers Against Trafficking on human trafficking with an emphasis on a victim-centered approach and the social attitudes that contribute to and misunderstanding of prostitution. This training is central to a powerful survivor's testimony with her perspectives on interactions with law enforcement that she encountered. During COVID, many of our agencies have been utilizing TAT's training video for law enforcement. In fact, Las Vegas Metro Police Department will be training an estimated 3,000 officers in their next in-service. In addition to the Truckers Against Trafficking, Busing on the Lookout was launched in 2019 in Las Vegas and in Reno in January of this year. In Reno, we trained over 149 individuals from the casinos, transit, and real estate industries. With our efforts, we ask that you please support and help us put an end to this horrific crime by passing AB 182 and stop the illegal prostitution that is happening in our local businesses. Thank you, Chairman and Committee and Assemblywoman Jill Tolles, for your time.
Thank you for your testimony, Ms. Yeager. BPS, do we have anybody else on the line in support?
Chair, there are no further callers in support at this time.
Thank you, BPS. And I will note for the record that there are some letters in support that are uploaded to Nellis under the Exhibit tab. We heard from a few of those individuals, but one we didn't hear from, and I wanted to flag that there was a letter in support from Dignity Health, St. Rose Dominican, that is uploaded on Nellis as well. So I'll close supportive testimony. I will now open opposition testimony. We don't have anyone in opposition on the Zoom with us. BPS, could we go to the phone lines to see if there's anyone there in opposition?
Thank you, Chair. For callers wishing to testify in opposition of Assembly Bill 182, please press *9 now on your phone to take your place in the queue. And we will begin with caller with the last 3 digits of 447. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you. My name is David Figler. First name spelled D-A-Y-V-I-D, last name F-I-G-L-E-R. I am a criminal law practitioner and a former municipal court judge for the city of Las Vegas. Chairman Yeager and members of the committee, I appreciate I might be the only person here in opposition of what I deem to be a very troubling measure. I'm hoping that I don't go over my 2 minutes, but if I do, given the amount of support, I'd hope to get a little bit of leeway to point out those provisions that are particularly distressing, given where we are with criminal justice reform in this country and the state right now. First off, though, however, I'd like to commend Assemblywoman Tolles and this committee for striking the clearly problematic provisions of NRS 201395, specifically the known or should have known language. As was raised at AB 166, it is particularly problematic with regard to due process and constitutionality. So I'm glad to see that's gone, and I hope that whatever happens, that does get stricken. The problem with this particular statute is twofold. One, it does make ordinary citizens, and I appreciate that most, if not all of the testimony talks about trafficking, which is, a serious concern, and exploitation, a serious concern, but neither of those words appear in this statute. This statute, as proposed under AB 182, is far more broad, and that's where it becomes problematic. It essentially creates criminal liability for those who are passive or indirect participants by either giving a place or managing a business where the police unilaterally claim, without any manner of vetting, that a single act of prostitution has occurred. Now, I appreciate some of the testimony about it being certified letter and thoughtful investigation and arrest reports, but none of that is required in this particular statute. Indeed, it just says notice. And now I can tell you anecdotally, as a municipal court judge, that I heard many cases where the police alleged that there were acts of prostitution in adult cabarets. Most of the time, an inordinate amount of the time, those allegations turned out to be false. The problem with the statute is it has no threshold of proof. There is no procedure to challenge that particular notice. What is required in that notice is not provided for. And there is no penalty to law enforcement if that notice is either false or below whatever threshold of proof people are considering. Additionally, it creates liability at a Category C felony level, which is really outrageous considering that active participants under other provisions of NRS 201, the nonviolent person who lives from the earnings or derives proceeds, the person who places a person in a house of prostitution, these are only Category D felonies. And then, of course, the act of prostitution itself is only a misdemeanor. And then there are some provisions that only provide for administrative fines. The second issue is the vast and inordinate amount of discretion given to law enforcement with the power to coerce these individuals who are otherwise potentially law-abiding citizens into cooperating, and I'd say colluding with the police in a manner that is akin to conscription. Essentially, you don't have a limitation that the mom and pop landlords who are informed that there is a sex worker who is utilizing the apartment have a choice. They could either kick that person out to the street, or they can engage in whatever this ambiguous cooperation with unrestricted undercover operations and surveillance amounts to. So in essence, what this is essentially a workaround for warrants and other protections of the Constitution, especially relates to the Fourth Amendment, to allow the law enforcement to engage in activities to conscript otherwise law-abiding citizens into cooperation in ways that there is no control, there is no vetting, and there certainly is no statistics as to whether or not this is disproportionately impacting communities of color. In essence, and this would be my concluding remark here, if this is about massage parlors, as indicated, there are provisions in the NRS 640C and NAC 640C, which would allow for additional measures to be presented. And certainly every municipality has massage parlor regulations, which would go and hold accountable those bad actors who are engaging in the type of activities that people who have testified here today have mentioned. But ultimately, under this particular statute, I would recommend that it be revoked and repealed altogether. Under this, you're providing yet another unnecessary tool, ostensibly to end sex trafficking and exploitation, but really measure targeting sex work and prostitution. But really more than that, it's a measure to give more discretion to the police to coerce or conscript citizens into aiding law enforcement to continue to engage in all of the entrenched and systemically challenged methods that police have been criticized now for, which lead to calls for reform, defunding, and greater oversight, and which invariably affects communities of color in a absolutely disproportionate way. I understand the preoccupation with sex trafficking and exploitation. This statute never, at least in this current form, is not simply narrowly tailored for that, but for a much broader purpose, which runs completely counter to what we're trying to do. And especially given that our vice departments here in Southern Nevada and throughout the state are not transparent in their methods, how they use surveillance, how they have themselves.
Mr. Figler, can I just ask you to wrap up? We are well beyond 2 minutes. If you could just conclude, please.
And thank you, Chairman Yeager, and I appreciate that accommodation. This is not the approach to accomplish the goal, but while it is claimed to be more narrow, I agree with some of the comments of the Assembly that this is actually much broader and capable of greater exploitation by the police department when we look at the ambiguous language of the notice and we look at the ambiguous language of cooperation or abatement, which could mean that you have to throw people out to the street, or in the cabaret's example, fire that individual even if they did not commit an act of illegal prostitution, because it's more expedient to avoid the harsh penalties of a Category C felony. I would implore that even if none of what I'm saying resonates with you, that you reduce the criminal liability here from the high Category C to either a gross misdemeanor wobbler or a Category E felony. It shouldn't be more than those who directly participate in the actual ills that you're seeking to redress. And I appreciate that extra time, Chairman Yeager.
Thank you, Mr. Figler. And indeed, in recognition that you may be the only one in opposition, I did give you quite a bit more time there than 2 minutes. So hopefully you're able to make your points. And if not, I always encourage you to communicate with the committee in writing. BPS, do we have anybody else on the line in opposition?
Callers wishing to testify in opposition of Assembly Bill 182, please press *9 now on your phone to take your place in the queue. Chair, there are no further callers for opposition at this time.
Thank you so much, BPS. I will now close opposition. I'll open neutral testimony. I don't believe we have anyone on the Zoom with us in neutral. BPS, could we check the phone lines to see if there's anybody there, please?
Yes, thank you. For callers wishing to testify in neutral, please press *9 now on your phone to take your place in the queue. And we will begin with caller with the last 3 digits of 765. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, everyone. My name is Caitlin Gwynn, Caitlin Gwin, and I'm calling as a representative from the Sex Worker Alliance of Nevada. We are neutral on this bill, so I just want to take some time to add some general context. First off, I want to thank Assemblyperson Tolles for changes that indicate that she heard our concerns from last session's AB 166. I do think that this bill is an improvement, but I still disagree with the general spirit of the bill. Assemblyperson Tolles and I have the same goal. We want to protect the exploitation of vulnerable workers. I think we just have different ideas on how to do this. We know that many people doing sex work are doing it because it is their best or only option for work. This sort of circumstantial sex work is an indication of problems with unemployment, our immigration system, and poverty in general. Instead of addressing this problem with arrests and raids, which we know are traumatic and often end up in the arrest and deportation of unwitting workers, let's put the power in the hands of the workers who you identify as victims. Let's prioritize retraining law enforcement to have a nuanced perspective to understand the difference between consensual work and non-consensual sex trafficking. There's a lot of work that needs to be done in this regard. In fact, in a recent meeting with Metro, a researcher asked Metro how they identify the differences between consensual sex workers and trafficking victims. And they said, and I quote, "I do not understand the question." Let's allow these workers to make decisions about their own lives. Let's make sure we are focusing on stopping acts of violence rather than acts of desperation. If they are victims, let's give them the resources to report their traffickers. Let's protect them from arrest and deportation, and let's trust what they say. Thank you so much for your time.
Thank you for your testimony in neutral, Ms. Gwynn. Appreciate it. BPS, is there anybody else in neutral?
Yes, caller with the last 3 digits of 695. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman Yeager, members of the committee. This is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada, testifying in neutral on AB 182. It was a pleasure to have a thoughtful conversation with Assemblywoman Tolles on this legislation, and we do appreciate her commitment to this issue and to building consensus. We're neutral on the bill as it takes some steps to mitigate harm to consensual sex workers, such as requiring actual knowledge and providing an opportunity to abate. But we remain concerned about the ongoing trend toward third-party criminalization and its impact on consensual sex workers. The ACLU of Nevada and the Sex Workers Alliance of Nevada submitted a letter with data for the committee to consider when addressing these issues. We look forward to continuing a broader conversation on the issue with Assemblywoman Tolles, with each of you, and the legislature. Thank you for your time, and please feel free to reach out to me with any questions you might have. Thank you.
Thank you for your testimony, Ms. Wellborn. We hope you had a great birthday yesterday. VPS, is there anybody else in neutral?
For callers wishing to testify in neutral on Assembly Bill 182, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS. I'll note for the record that there was also a letter that was referenced by Vice Chair Nguyen in the neutral position, and that is uploaded on Nellis, as well as the referenced letter from the ACLU. So members, you can check there for more information if you are interested. I'm going to close neutral testimony, and I will now invite Assemblywoman Tolles to make any concluding remarks you'd like to for the bill.
Thank you, Chair Yeager, and thank you again, members of this committee, for allowing me to bring forward this legislation. And thank you again to all the stakeholders over the interim who brought this to my attention, who requested this bill, who helped me to refine it, and individuals who called in and offered their thoughts, comments, input, suggestions today. And I always appreciate this dialogue, and I always appreciate the larger conversation that individuals are attempting to address. I do want to respond to the comment that this is very broad, that actually there was so much effort put into this particular language and legislation to ensure that it's not broad. It has a very, very specific language about what constitutes a violation, what written notice needs to be involved, and a series of steps, of options of steps that businesses could take to help ensure that they would not fall into this category of being guilty of this felony charge. And so I do want to say that I appreciate all the co-sponsors who have signed on. I know a couple of the members of this committee have also asked if potentially they could sign on. I'm open to adding any other co-sponsors. I'm also, as always, open to collaborating and seeing if there's ways that we can continue to perfect and refine this language. I appreciate all the questions of this committee so that I could make my intent and the intent of the supporters of this bill as clear as possible on record of exactly what it is that we are trying to accomplish. But there is always in this process room for improvement. So I'm grateful to all of you for being a part of that discussion today, and I do hope for your support. Thank you.
Thank you, Assemblywoman Tolles, for the presentation, for the concluding remarks, and thank you to those of us who joined us on the Zoom to help answer questions. Assemblywoman, it was good to have you back in the Assembly Judiciary Committee this morning. Hopefully we'll see you again in the very near future, but until then, have a good weekend. With that, I'll close the hearing on Assembly Bill 182. We're now going to move to our final item on the agenda, and that is public comment. By way of reminder, we'll take up to 30 minutes of public comment at the end of each meeting. Callers will have 2 minutes to provide public comment, and public comment is a time to bring up matters of a general nature that are within the jurisdiction of the Judiciary Committee. VPS, could we go to the phone lines to see if there's anybody who'd like to give public comment this morning?
Thank you, Chair. For callers wishing to provide public comment, please press *9 now to take your place in the queue. Callers wishing to provide public comment, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. My brother Thomas Purdy was 38 years old when he was killed by Reno police, hog-tied during a mental health crisis and asphyxiated to death. I just wanted to remind you all, please do not support bills that promote bad policing and protect bad police. Please promote and support bills that promote transparency and accountability. Have a nice weekend. Thank you all for your hard work. Bye-bye.
Thank you for your public comment, Ms. Grant. BPS, is there anybody else on the public comment line?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS. And as always, thank you for helping us get through the technical part of the meeting. We appreciate it. I will close public comment. And before we talk about next week, I will invite any members of the committee who have anything they would like to add at the end of week 5. Okay, you all look as tired as I feel right now, so maybe that's an indication of where we are. But I want to thank all of you for your hard work this week. It's been a long week. Of course, we have several long weeks ahead of us as we march towards our first committee passage deadline. In terms of where we go from here, there are agendas out Monday through Wednesday of next week. Monday is a 9 o'clock start, so we'll get an extra hour. I just don't know yet what we're going to be doing towards the end of the week. I suspect we're going to be hearing bills, but we just haven't figured out which ones those are yet. So stay tuned for additional agendas. I'm not sure that we'll have the luxury of taking any judiciary meetings off from this point on, but we'll just see how things develop. So with that behind us, again, I want to thank you all. I hope you have a wonderful weekend, and I'll see you all back in this committee on Monday morning at 9 a.m. This meeting is adjourned.
Chair. I thank you, Chair.